Good morning, everybody. It's time now for the inquiry to resume on day 18 of the inquiry in what should be the penultimate week. A few things to mention before we get underway with evidence. Some minor updates to the programme. There is an updated version on the website, but in terms of tomorrow, we expect to hear evidence from Mr. Whitby on ecology for the applicant before Mr. Franklin. There's just been a request to move those two witnesses round. The programme officer has also had an approach from a county councillor, Rees, who indicates that he might like to speak at the inquiry and asked about the opportunities for that. As I said when the inquiry opened, we would always check before it closes whether there is anybody else who wishes to speak. So we were given that opportunity, and we've suggested either the end of today, if that's convenient for him, or possibly on Thursday. Currently waiting to hear back, and because it is now close to the end, we have asked for an indication of his notes in advance so that all parties can be aware of what he wants to speak about. Just for the point of clarification about next week on Thursday, there's a round table with a review of the order, and we would expect any discussions on the book of reference to take place then as well. I think that covers programme updates for now. A word about documents that we've accepted into the inquiry since we last met. The applicants submitted the revised version of ES Addendum 3, less the specific references to Clare Hall, which triggered this. So, as we indicated last week, that's accepted. Mr. Sullivan, who spoke a little while ago, wanted clarification about the documents that he'd submitted. I think he submitted about half a dozen documents. Two of those are already in as inquiry documents, so there's no need to accept those. A number deal with his consultation responses on the East-West Railway, which is a different project, of course. So the two that we have accepted are his email chain, and there is a bundle of plans. We've accepted Plan 3, given that that does make specific reference to the busway. So two of Mr. Sullivan's documents are in. There's a further judgment that's come in ahead of closings from the applicant. That's the more due judgment. So that's accepted, as we would do with closings in any event. And we have a note from the ecology witness for the applicant, Mr. Whitby. Just a slightly different word about some other documents. Mr. Cameron, the programme officers received two documents concerning biodiversity net gain from the applicant relating to a very recent decision of the Greater Cambridge Partnership on how this is dealt with. And I think the date's the 6th of November, so clearly they couldn't have come in at an earlier stage. However, I think I need to ask about their relevance to the applicant's case, because given the subject matter, clearly we need to give other parties who've spoken on this topic an opportunity to consider and, if necessary, speak to them. So if you want them accepting, we will be extending an opportunity to CPPF and Coton Orchard to address those matters.
Yes, Mr. Henderson's dealing with this.
Okay.
So a couple of points. The first one is you've already noted decision date of the 6th of this month, so
yes.
Last Thursday. Simply no opportunity for us to provide those to you in advance. We gave them to you as soon as we did.
Yeah.
Secondly, in terms of their relevance and the scope of the point within those documents, it's actually rather limited. You're right that they deal with BNG for the Greater Cambridge Partnership more broadly, but it's a simple point which is about the brook and the watercourse units. That's actually the only point we seek to draw from those documents. So you've heard already from us in our written material about Lower Valley Farm and the habitat units which are available there. We don't rely on the document for that purpose because you've already got some evidence about that.
Yes.
I've already asked Mr Woodfield about that. It's on the much narrower point of watercourse units. If some watercourse units are required, bearing in mind there will only be a small amount, the question then is where are they going to come from?
Yes.
There is the potential for some delivery on site, probably not the entirety, notwithstanding it's a very small amount. The question then is where do they go? Well, the answer is the GCP have identified this site on Thursday where they go. In any event, we could simply pay for the credits off-site, but to give you the full picture, that intervening step, this decision document explains the brook's been identified, it's part of the programme, and it will be an available site for those watercourse units.
Yes.
Specifically. So that is the relevance, that is the point we seek to draw from it, and that's as far as we go.
Yes.
And we've given it to you as soon as we could, and Mr Whitby will essentially explain in slightly more detail what I've just said to you in the last 2 minutes.
Okay, Mr Henderson, thanks.
And
So,
I should say, sorry, just on the prejudice, sorry, the third point.
Yes.
CPPF knew about this
yes.
because Mr Littlewood made representations to the committee on the report before the decision was taken on Thursday.
Yeah.
So they're not blindsided by this. Mr Littlewood's seen it. And in respect of Miss Jaisley, with respect, it doesn't touch on the orchard because we're just talking about watercourse units and her concern is about the trees.
True.
So the watercourse point's only been raised by CPPF, and in any event they knew about this because Mr Littlewood made some representations at the relevant time.
Yes, but that was not representations at the inquiry.
Not on the inquiry, sir, but just in terms of the point of prejudice about letting it in the door.
Yes.
I understand you might want to give him the opportunity. I'm sure Mr Parker will put some questions to Mr Whitby if he chooses to do so.
Yes.
But just on the preliminary step of letting the documents in,
Yeah.
they knew about it.
Yeah. And just to make absolutely certain, you do want the documents in?
We do, sir. I mean, I'll get Mr Whitby to explain what I've said to you, but it seems to me better that you have both his
Yes.
explanation plus the document which explains that to you.
Well, on that basis, we're entirely happy to accept them, but we will just double check with both the parties I mentioned before.
Yes, of
whether
course.
or not they wish to say anything.
Of course. Thank you.
And I think the final point I want to raise on documents is concerns Mr Franklin. The programme officer has received an email concerning his evidence, and there seems to be reference to a possible addendum which we weren't aware of. Can somebody enlighten us?
Yes, sir, I can. You'll see in section 5 of his evidence, I think it's section 5 from memory, that he has a chapter heading Progress on Agreements and Summary of Engagements.
Yes.
And he can either tell you orally what changes have occurred since he wrote his evidence, or he can provide a bit of paper which sets that out. So the additional document that we're envisaging is a schedule which just brings you up to date
I see.
and where negotiations are with each
Right.
party.
Yeah.
And if that, as I say, he could do it orally, but we just thought it would be easier for everybody if he put it on a
Yes.
piece of paper.
That seems to make sense, Mr Cambourne. Given that Mr Franklin's due on tomorrow, when are we likely to
Well, I
receive the
hope.
schedule?
I mean, he's drafted something. I hope it goes in today so that people can
So do I, yes.
have it. And I hope those in the team who are hearing this
Yes.
get that message to Mr Franklin now.
Good, good. So we can expect it after the lunch adjournment?
I hope so, sir.
Yeah.
Yes. I don't see any reason why it shouldn't be. On Councillor Rees,
Yes.
I've just had because I hadn't heard about this before you
Yeah.
mentioned it. I don't think he's an objector. I can't find him on the list of objections.
You're quite right. He isn't on the list. I don't think he's on any list.
No.
There are some references to members. We've checked those, and he's not in those groups of members. So, at the moment, Mr. Underwood and I do not know his position.
No, and I appreciate, sir, that see there is a discretion from permitting any other person to appear,
Yes.
looking at the rules, not to be unreasonably withheld. We don't object. We don't know what he's going to say. But if he's able to produce something in advance, we would find it useful, because if he then says something that I don't have instructions on,
You can check. Yeah.
might ask for him to come back so I can ask those
Of course.
questions.
We've already asked that question.
Thank you.
And just going back to objections, there are two updates in that we've had two withdrawals of objection. They're from the University, Rugby Union and Football Trust, and a second one from Bedlam and Chivers Farms. So those two objections are both withdrawn. They are both statutory objectors, as far as we're aware, and we want to be able to clearly identify the statutory objectors in our report to the Secretaries of State. There are a great number of objectors, not all, which are statutory. And to that end, we've prepared a schedule, which is now on the website at core document 2524. Given the large number of objectors in this case, and the fact that due to data protection, a lot of them have addresses redacted, so we're not quite sure exactly where they are from, we'd be grateful if parties could check the schedule, and if they're aware of any omissions or inaccuracies, please do let us know as soon as possible. And
Checking that reference, I went to 2524.
did you not find it there? I may have given you the wrong number.
No, you've given the correct number, but what one gets is a site visit programme rather than a schedule. So
Yeah.
all your work has gone to waste, sir.
Right, it's okay. It's okay. I'm sure that will be remedied
Yeah.
very quickly.
Thank you.
Yeah, the document does exist. And finally, from me for the time being, just a quick word about site visits. And I just wanted to let the inquiry know what Mr. Underwood and I saw last week on Thursday. We started off with a bus trip at peak time from Cambourne into Cambridge, and not just to the area where the busway is due to end, but all the way to Drummer Street bus station, so that we were aware of what was happening on the area where the road parallels the busway route, but also the onward journey into the city centre. So we've done that. We then walked back to the Grange Road area, followed the route of the proposed scheme to the west of Binbrook. We've also been along Adams Road and into West Cambridge, along Charles Babbage Road, towards and over the motorway, walked through Coton, along Whitwell Way, Long Road and into Hardwick. So we've done all that unaccompanied. We just wanted to update you on the extent of what we've seen. And obviously we'll be following that up with additional site visits, including accompanied site visits next week.
And having done those, there's a number of sites where we had some questions as to whether or not we thought we might need to either visit accompanied or to get access arranged, and we've provided a sort of list of clarification through Mrs. Vincent, which has hopefully got to you. So there are now sort of fewer sites where we're asking you to arrange access for us, because we're able to actually gauge what we'll be able to see or actually inspect sites from public places. So that should mean that hopefully the list that you accidentally came across there, Mr. Cameron, might be slightly shorter. I think on the Clare Hall end, but otherwise that schedule's fine. But there are, as I say, quite a few sites which, again, we probably don't need access to, having seen them. So, thanks.
Good. Just before we move on to evidence for today, does anybody else have any queries, points they wish to raise? Anything from the applicant, Mr. Cameron?
No, thank you, sir.
Anybody else? Right, we'll, the programme for today is, first of all, we've got two witnesses being called on behalf of the applicant, Mr. Saunders first, and then Mr. Wilson. We're then moving on to evidence on flood risk from Mr. Southam, and finally, noise and vibration from Mr. Lewis. So we'll go to Mr. Saunders first. Mr. Saunders, the recall is specifically to deal with questions that were raised by Mr. Burford when he spoke earlier on in the inquiry. You've already been introduced and given evidence in chief. So we were proposing to go straight to questions from Mr. Burford.
Yes, sir, that's absolutely fine by us. You've already heard, as you say, evidence in chief inclusion on these matters.
Yes.
So we don't seek to repeat those. You've already got a note.
Yes.
And simply for the questions to be put.
Mr. Burford, then it's over your chance to put questions to Mr. Saunders.
Thank you, sir. I will be referring to documents. I won't give out the CD number to everyone unless either Mr. Saunders or yourselves ask me. Mr. Saunders, I'm going to be referring to the IAQM document, which is CD 29-25-1. I don't know whether you want to refer to that at all at this stage. But, Mr. Saunders, you refer to the IQ, if I can call it the Institute from now on,
Yep.
Throughout your report. Why wasn't the full report included in the pack presented to the inquiry?
Well, principally, the environmental statement takes the methodologies from the IAQM and then adopts them and includes them within the technical report itself. So it's CD 11102, which is the environmental statement air quality technical report. That takes, for example, the methods and then applies them to and then includes them within the environmental statement itself. So effectively they're all in one place.
Thank you. Throughout the Institute's guidance, it states that you cannot be prescriptive about dust.
Yeah.
Would you agree with that?
Yes.
And yet, on the other hand, it does stress that professional judgment should be used. You will agree with that?
Yes.
Can I ask you if you've had any training on the Equality Act, Disability or Discrimination Act, or the Human Rights Act?
Have I personally had that training?
Yes.
Apart from a corporate training on those matters, along with other corporate training, no.
Okay. And are you aware that under the Equality Act 2010 there's a duty on public authorities to make reasonable adjustments proactively when they're made aware of a disability?
I'm aware of the Equality Act, I'm aware of the public authorities' duties, and I'm aware of reasonable adjustment, not to any full degree, but I'm aware of that wording.
The wording is reasonable adjustments proactively.
Yes.
The requirement under the Equality Act includes adjusting any plans before they cause harm. Do you agree that there is currently not a spade in the ground and there is the opportunity to be proactive and adjust the route?
I wouldn't necessarily say from adjusting the route perspective, because it's probably more about the mitigation that can be employed, particularly during the construction phase. I would say the alignment of the route is principally an operational issue, And I can cover that in more detail if necessary, but principally it's about the measures that can be employed during construction that can be proactively employed to address particular situations.
Come back. So really that would be a question for Mr Baker then, would it? And perhaps
In terms
if
of
it's
adjusting the
operational.
route line. In terms of adjusting the route line, what I can deal with is any air quality impacts that are from the operational phase result from the proximity of the route to your property.
But they're not in any of your documents, are they?
The results of the assessment are in terms of predictions for operational air quality at certain receptors along the route.
Isn't that for traffic?
That's traffic. So I'm talking about the operational alignment, effectively, and so yes, from a traffic perspective.
So, okay, we haven't got any assessment on the construction at the rear of my property.
We have assessed properties and we've looked at the risk, not necessarily specifically to your property, but we've looked at the risk associated with properties within distance bands and taking into account other factors as per the Institute's guidelines. So numbers of properties, distances, activities that take place, and looked at those and the mitigation, and then through that risk profile, then moved on to potential mitigation measures that could be employed. And they're the mitigation measures that are set out in the Code of Construction Practice, which is CD 126.
Yes, I've read that. Forgive me, I'm a layperson. So what I said was, you've assessed the traffic on the road involved
Yes.
with deliveries and what have you, but you've not assessed the actual operation behind my property.
We are talking about, are we talking about operation of the scheme or construction?
Construction.
Construction, right. Well, there has been an assessment from a risk profile looking at the using distance bands and then from that risk profile comes the mitigation measures that could be employed, and then taking those into account has been all those measures that are set out in the Code of Construction Practice.
Okay.
And it's acknowledged that your property is within. We've talked about 100 metres quite a lot has been a appropriate distance. Yeah.
Regarding the scoping document, who decided who decided what should be scoped in and scoped out? So
with an environmental impact assessment scoping exercise, the duty is to report likely significant effects. So each individual discipline, so that could be air quality, noise, ecology, will go through a process and look at the receptors, the sensitivity of those receptors, the likely magnitude of impact and likely significance, and then they will propose through a scoping report to whether or not those factors should be scoped in or scoped out of assessment. That scoping report is then submitted to the sort of determining authorities, so local planning authority or similar, and then a scoping opinion is provided, and the applicant can then take on board, well, usually would take on board those that scoping opinion, and then that will be translated through into the environmental impact assessment that's undertaken for the scheme. That's because obviously a huge amount of detail could go into these documents, but the idea is that you are reporting likely significant effects. So there will be a lot of effects that could occur but would be insignificant. So the idea is to try and make it a focused document, and that's the whole process basically. So the applicant proposes what should be scoped in or scoped out, and then it is an opinion is provided on that scope by the local planning authority or similar.
We talk about the dust. Can we agree that we're not talking about normal household dust? Can you remind me of what construction dust actually contains?
Well, it very much depends on the material on which the plant, etc., will be tracking over. So you'll be able,
behind my property.
yes, behind your property. So the agricultural land, I believe it's a loamy soil. It's currently cultivated. We look at particulate matter in particular for dust-related matters. So that's the key one from a construction perspective. And then
That's PM10.
yes, PM10 and PM2.5, but yeah, particulate matter.
Now, the 2.5 is the dust that travels distances.
Yes.
Who knows how long,
Yeah.
depending on all sorts of factors. And the one that can get into the bloodstream and damage the heart and lungs. That's the one, isn't it?
That's PM10, yes.
PM2.5.
I'm sorry, PM2.5, yeah.
That's the really fine one.
Yes, fine
In my
particles.
language.
Yeah.
Okay, given your experience in projects such as this, what's your estimate of how long the construction for evacuation and track out will be from between the waterworks, Long Road, and the M11 bridge?
I know the construction phase is 2 years, estimated in total. I've asked the people who've been responsible for construction about the situation in proximity to your own property.
No,
So
along that route.
along that stretch, yes. I've been told that that 3 to 6 months is the period through which there would be excavation. Initial
All right,
excavation.
so the first, yeah.
Yeah, so
So 3
initial
to 6.
excavation. So effectively the topsoil strip or whatever is required. Then there would be a period, and it obviously would be quite transient. It would work along the scheme. There would then be the haul road that would be put in, and then
And the length of time of that?
the haul road being put in would be fairly quick, and we've discussed about one of the adjustments being the fact that the haul road would be sited to the south side of the order limits. So, in other words, furthest away from your property. And the key risk is probably around the actual exposed earth itself. So once the haul road's gone in, the impact and the fact that it would be located further south.
So just the time at the moment, thank you.
Timescale for timescale for haul road, it would be. I honestly can't say, but in my experience, it would run. You'd usually put something like tram down and then some base, and then you would run, and that would go in fairly quickly along the trace. So I don't think. I think the actual installation would be a short period of time, but then obviously the traffic would run along that for that period.
Okay, so we could say up to 12 months.
I don't know all the details because
Okay.
I haven't looked at the construction programme. I have asked the construction team about their estimate as to when the earthworks would be most exposed, and they said 3 to 6 months before other activities come along that reduce that area.
In your proof of evidence, you state that there are several adverse effects predicted temporarily during construction, including noise, vibration impacts, and a reduction in visual amenity. Why have you not mentioned the air quality during this phase?
Sorry, that's probably talking about
That's CD 2601 app W3-1 at 0.4.45.
The answer I give without looking through the documentation was that they would typically they would look at where I mentioned before about likely significant effects. So there are, for example, could be likely significant construction noise effects, likely significant visual effects, but it is contended that, or assessed that the impact on air quality would not be significant in terms of, sort of environmental impact assessment significance criteria because it can be mitigated.
But how do you know that if you've not done a risk assessment on dust?
Often with construction matters, it is then the design is then developed, and the code of construction practice, which is an outline code of construction practice, that would be then the requirements of that would then be used to develop a local environmental management plan with the work of the contractors. Now, it's very difficult at this stage to estimate exactly what plant would be running where over what duration. When you get to more detailed design and a more detailed programme is put together, and the local environmental management plan is formulated, and working with the local planning authority, that is when controls, monitoring arrangements and those sorts of things can be put into place. And it's with all those measures put into place that, using professional opinion, etc., the air quality team would conclude that there's a very high likelihood of no significant effects.
What is you talk about temporarily there. What's your definition of temporary?
It does vary. Guidance is, it usually assumes a 2-year construction. Very typically, it would assume a two-year construction build for most projects are a sort of 2-year duration. For the projects of this nature anyway, that's not untypical. But bearing in mind that because it's a long linear route, and it would move along the route, so it would be temporary at different locations over time, and particularly as construction progresses, and then the topsoil strip takes place, then the sub base goes in, and then the top layer goes in, and tarmac, etc. Then, overall it keeps capping it, and therefore the construction effects minimise over time. So I think there's a particular window where there's a greater risk, which is the early sort of topsoil strip and management through that period. So I think that's where the greatest focus would be in determining some bespoke mitigation measures.
So in your opinion, will the impact on my wife's health also be temporary?
I can't say. All I can say is that we're obviously very aware of the situation. From an operational perspective, so moving past the temporary construction perspective, there's an overall benefit. Moving through the construction phase, this is all about the quality of the mitigation measures, the understanding of your wife's condition. It can be programming. It can be certain measures such as temporary fencing and those sorts of measures that can be put in place. But in the long term, obviously currently it's a field that's ploughed. It has crops that get harvested. In the long term, you have a intervening or bisecting of the field, a solution that has planting. There are some, albeit small bunds. The field is no longer as it was previously, and in my opinion, there's a long-term better solution there.
At the rear of my property, do you agree that in any one day there'll be 50, or up to, according to your report, 50 diesel-powered heavy-duty vehicles making return trips on a dust track behind my home?
The report makes estimates at the time. I mentioned, so the simple answer would be quite possibly, yeah.
My wife has been requesting a dust risk assessment since June this year, so that it could be presented to this inquiry. Why have you or Mr. Baker ignored the request and not carried one out? Do you agree it would have been useful for the inspectors in order for them to make an informed decision about the measures that she's asked for, if you had done one?
The dust risk, I've mentioned already that this very much goes into when there is the detailed design, the understanding of the contractor's methods, and how they might want to build it, the programme that's involved in building that, and understanding all those aspects, so that then therefore that they can be devised and agreed with local planning authority, etc., at the next stage. So it's at this stage we're making an assessment, an environmental impact assessment on the information that we currently have, the dust risk assessment will be undertaken at the next stage when there's more details from the contractor about the operation, the duration, nature of plant, and so on.
Okay, thank you. Regarding your evidence, Mr. Henderson, when Mr. Henderson questioned you, I felt that he was almost dismissive of my wife's concerns concerning her health, and asked you quickly whether you thought that any of the mitigations that my wife had requested were necessary. You basically answered no, they were not necessary, and stated that COP would mitigate the impact of any dust. Correct?
I don't recall it as being like that necessarily. I think we...
Well, I was here. I heard it on YouTube.
Mr. Burford, just let Mr. Saunders answer your question.
Yeah.
Fine, sorry.
Yeah. I think we were acknowledging the location, the situation, the location of you and your wife live. That there are a suite of mitigation measures that are listed both in the environmental statement and in the Code of Construction Practice. In total, there are 69 measures that are currently in place, or have been put into the Code of Construction Practice that relate to air quality and construction. And then there's another suite of measures that relate to monitoring and how to react and respond to any breaches of any issues that relate to any exceedances of agreed dust levels. So I would say that we would certainly be taking it seriously. We've talked about how the local environmental management plan would be coordinated and the types of people that have that responsibility for coordinating those. And we do acknowledge it through more detailed discussions, understanding of the programme, the plant, etc., that there could be some measures that wouldn't be dismissive. They would respond to any risk assessment and what the contractor has proposed. And I think, as we've mentioned, realigning of the haul road southwards, any temporary fencing. There are lots of measures these days around dampening down of dust and so on and so forth that can take place, including with chemicals, and to bind them. So those are the sorts of things that could be employed, and you wouldn't employ them across the whole of the scheme because it wouldn't be proportionate or right, for example, to put hoarding all the way along the scheme, but you can respond to particular situations and properties, and this would be a case in point.
Thank you.
Sorry to interrupt, Mr. Burford. Can you just remind me, the question that you just asked was about the adjustments that you had requested or your wife had requested. Could you just remind me what those were?
Well, basically, she's very concerned about the proximity of our property and the fact that there had been no solid...
What the actual adjustment, what the change...
Well, she asked for the busway to be moved 100 yards, I think it was 100 yards, 100 metres further away.
Was that the adjustment, or were there other things that she asked?
Well, I mean, clearly there would need to be mitigation, because even if it was moved sort of 100 metres away, it would still be relatively close to it. So, along with other mitigation measures, that was it.
Thank you. I just want to be clear what the context of the question was to Mr. Saunders. Thank you.
I don't know if I could help in that it's objection 211. Sorry, I don't know the CD number, but it's those.
It's okay. It was just to help me whilst we go on. Please carry on, Mr. Burford.
You mentioned 69 measures. I have had a look at the COP. I think probably 60 of those are about washing wheels and damping down and health and safety for the workers. But moving that aside, the problem I have is all of those things are respected. They're not proactive.
Yeah.
That's my problem.
Yeah.
Because if it's happened and I can make all the phone calls I want to anybody I want, it's too late.
Yeah. I can respond on that if it helps. They are Institute of Air Quality Management measures. They do cover all eventualities, so that can be all sorts of different things. There are things about damping down, locating construction plant at particular areas, and so on and so forth. Now, the fact is that all of those are in the draft code of construction practice. They would make their way through into local environmental management plan. They would be signed off by the relevant local authority, and then it would be the responsibility of the contractor and their environmental management plan coordinator to make sure that those are enforced through regular site visits and monitoring. Where what we've talked about are perhaps some additional measures on top of those that could be bespoke. So we've said that certain properties are within a particular risk area. We would apply all these Institute of Air Quality Management requirements because they would be that they are set out. They'll be translated through. They'll be captured in a condition. I think it's condition 9. But then we would liaise with yourself through. We'd have the dust risk assessment. We'd have individuals from the contractors and their environmental representatives, and we would understand any particular requirements and respond to those as necessary. And from my experience, I've worked on a fair few construction sites as well, and it is always the case that there are issues or sensitive receptors along the project where you would perhaps go over and above what is set out there because you're responding to life on the ground effectively. So all these are, I wouldn't call them business as usual, but these are the additional measures on top that would help reduce the impact. And then there's a commitment to, we've talked about moving the haul road, we've talked about potential barriers, and there would be a lot of liaison with yourselves to understand things probably around timing and all sorts of other issues as well.
Mr. Saunders, assuming the alignment of the busway stays where it's proposed, are the bespoke measures that you envisage on top of other measures, the things you've just referred to, the position of the haul road, fencing on the boundary? Is there anything else that you'd like to draw attention to?
There are measures, I think, that would be employed through perhaps the more detailed dust risk assessment. So in my experience, it's always things around damping down, being aware of future weather conditions and responding to those as well. Very often now contractors are obviously very sighted on that and they can respond accordingly. There can be things that can be done. I've talked about the haul road, and that will be an exposed but controlled area. There's obviously the line of the road itself. Each side of that there are areas that will be perhaps I say stripped but more fallow over time, and then the planting etc. would go in. So there are probably some additional measures that could be worked out through the process that are very bespoke to that area. When looking at the sort of 100-metre distance from the property and along the trace, there's probably about sort of 130 metres of linear within the draft orders, if you know what I mean, that comes within that 100 metres. So there's about having some bespoke measures across there. But I think principally barriers, damping down, keeping the haul road to that side, and monitoring and communication are the things.
Thank you.
Can I just point out that if the haul road is moved to the south of the construction site, my property will still be within 100 metres?
Your property, yeah, it would be just on, yes. And well, the other point I would say is that 100 metres, we have been talking about that, but we also talked last time about how quickly the sort of decay away from the source can be. But yes, okay. I think it's just it's right on the fringe, isn't it? But yeah. But
how fortunate. Yes.
Yeah. Okay. The 100 metres is just really, it's an indication that there's potential for an effect. And thereafter, you look at the risk, and then you build in all the mitigation measures on top of it. So it's very common in environmental impact assessment to use distance bands as it could be noise, could be 600 metres. It could be air quality from operation, which is 200 metres. It could be dust from construction, 100 metres. They just set boundaries within which to look in more detail.
Thank you. Have you ever physically visited the site?
Yes. Well, I've looked at it from the NFU buildings up that way. Yeah. So I've seen the agricultural operations.
Have you seen my property?
I've only on Google Earth. I've not been to your property.
So you've not seen the back, only the front.
I know the vegetation arrangements, for example.
No, it's not.
Oh,
It's
sorry.
not what I said. You've only seen, if you've looked at it on Google Earth,
Yeah.
you can only see from the front. You can't see the rear.
Oh, sorry, I meant in plan view, above.
Ah, right,
Yes,
okay.
yes. Not on street view.
Okay.
Yeah.
So, I better explain. We have 3 bedrooms at first floor. Doors out onto a balcony. We have uninterrupted views of 20 kilometres. We like to enjoy our garden, although given what you've said we won't be able to. And also it's actually very windy up there. Right. So that's when you're saying to me, oh, COP, we could put up fences, we could put up barriers. You can't. You can't, because a fence, a barrier, will become a sail.
Mr. Burford, I do need you to get to a question.
Okay. Well, fine. Okay, I'll move on. Sorry. I've not done this before, so.
I know, so
Can we turn, please, to your technical report to CD1-11.02 Appendix L. It's a page, PDF page 107.
Yes, I've got that.
Now, I need to thank Mr. Cameron for this, because last time I was here I said there's absolutely no mention of my property in your documents at all, and he pointed this out. Now, I have to say on the day I couldn't really take it in, but this Appendix L is your construction dust assessment, and well, it's to scale, and we've got some approvals there. I don't know who they are. And above that, we've got colour-coded buffer zone.
Mm-hmm.
Agreed?
Yes. So that's the page 106. PDF page 106. Yeah.
Sorry. Did I say 7?
I think.
Can you...
Figure 1, just to be clear. It's
Yes.
Figure 1, is that right?
Yes.
Yes, it is. Everybody there? You can identify my property.
I can. Yes.
It's best to work from Long Road
Yes, I can see it.
across. Then there's I think there's a drainage
Yeah.
pointing south. And then you can,
Yeah.
my property. It's very, very hard to see. But if you look at my property, which extends 200 metres from St Neots Road, is actually in the 200 buffer zone. I mean, it's a terrible map,
Yeah.
but quite clearly it's positioned not where it is.
So the 200 buffer zone is
The dark green one.
dark green.
The 100 buffer is the light green. And there's no evidence of my property in there.
So when you say there's no evidence of your property in there, what do you mean by that?
Well, because you can just about make out my property.
That's just
As I said,
overlaid in a different colour. That's all it is.
well, it's 200 metres. The different colour is 200 metres. This is construction dust assessment. I mean, it's quite a serious document.
So The mauve colour is the red line boundary, effectively, the order limits, the central one.
Yeah.
And then it moves, graduated and moves out 20, 50, 100, 200. But I don't quite understand.
It's not
Is
right,
this-
is it, Mr. Saunders?
I'm not sure. I don't know.
I think at this scale it's quite...
Yes, it's
quite-
very
quite
difficult.
to see exactly where...
Yeah. So this
Well,
is a. Yeah.
So if we tried another way, it is quite easy to see the road in front of my property,
Yes.
or easier.
Well, the road's contained by the red line boundary sign.
No, sir, the existing highway
Yes.
at the front of my property.
Yes.
Mm-hmm.
My property is 200 metres in depth. So you can work it out that way, if you like.
I know that your property is 100. This is from memory, but I think your actual property to your house is 153 metres from St Neots Road. I think.
I'm not going to argue with that.
Yeah. So and this is simply a base map that's had overlaid the distance bands, and then the people who are doing the air quality modelling assessment or whatever will use different, more detailed base mapping to actually do the modelling. But I'm still don't quite understand the
Mr.
point.
Saunders, this is your evidence.
Yes, but I don't.
This is
understand
in
the
your
point.
evidence, and it's wrong.
I don't understand which bit
I'm
is
happy
wrong.
for you if you feel able at some point to prove me wrong, fine. But
He's just told you he doesn't understand why you say it's wrong. So if you say it's
Because-
wrong, you need to put the question to him, explaining clearly why you say it's wrong, so
Right.
he can respond. Because he's told you it's not.
it's not what.
He just told you it's not wrong. So if you think that's wrong, you need to challenge him on it now, not later, now.
If my property,
Yeah.
as we've agreed, is 50 metres from the construction site,
Yes.
why is it not in the 100-metre buffer?
I think it is. Is it not?
No.
It's very difficult to tell from the quality of this mapping.
I'll leave it for you to decide.
Is the issue here just what you can see
Yeah.
in terms of the underlay on it? Because I must admit, I'm looking at this as big as I can zoom in, and I can't tell whether there is something underneath the lighter green one or not. I can clearly see the sort of the area which is between your property and the end property nearest the roundabout in that in your sort of area of housing, because there's a sort of a shading there. I can't see anything. I can't see anything below that, but I can't tell whether that's because this green line's obscured it or because actually, as I think, are you saying that the area, the sort of the slightly shaded area which represents the gardens of you and your neighbours, ends at the dark line at the top of the light green?
Yes, sir.
Right.
Well, and logically speaking, if that light green one is 100 metres, some of my property should be on that light green, within that light green line. If it's been agreed that my property is 50 metres from the site.
So, Mr. Saunders, is part of Mr. Burford's property within 100 metres?
It is in reality, yes. Whether you can see that from that map,
And-
I don't know, but it would have been taken into account as a property. Mr. Burford's property is it is so the fence line to the order limits is 55 metres. The property to the order limits is 81 metres.
So just
Yeah, sure.
Property to
So-
the order limits.
The property to the order limits is 81 metres.
so when you say property, do
The
you
act-
mean the rear wall of the house?
Yes. Yeah.
Not the garden.
Not the garden. The garden to the order limits is 55 metres at its closest point.
55.
Yes. Yeah.
Thank you.
But I do accept that the quality of the map is not. I think it more demonstrates the principle that the map is trying to portray to the reader that these are the distance bands, but in terms of actual the reality of doing an assessment, then that map is just basically to convey that. Whereas the practitioners undertaking the assessment will have all the properties, a database of. Usually they use sort of post office reference points and things like that to identify all the properties within a study area. So it's understood which are the residential properties. But pictorially, that may not be the best map, but it wouldn't matter from the actual assessment perspective.
So are you saying the indications are that it's wrong?
I just can't see from that the quality of that plan.
Mr. Burford, I suspect Mr. Saunders has taken those questions as far as he can, and he specified the distances between the order limits and the house and garden.
Yes, sir. I believe it's wrong to present a document to yourselves, but
Yeah, but
I'll
we
top-
need questions to Mr.
Okay.
Saunders.
can you confirm, Mr. Saunders, that this map is the map presented to both the GCP Joint Committee and the GCP Executive Board for approval?
I don't know the answer to that. I just know that it's part of the environmental statement. And so that is just one of many plans that's in the environmental statement that's considered. I don't know what other purpose it might have served.
Okay, and can you confirm that this map was, when you were talking to the South Cambs Planning Department, when they put in their conditions and what have you, this is the map that was presented to them?
Again, I wasn't involved in that, but so I can't confirm.
Okay.
As I say, I can confirm this is part of the environmental statement, but I don't know what other purposes this map has served.
Who would know?
I could, I suppose Mr. Baker most likely would know. I can check.
Thank you. The Institute guidance states, we'll move on. The Institute states, guidance states that receptors within 350 metres of the site boundary and 50 metres from the route used by construction vehicles requires assessment. Did you carry out such an assessment?
Yes, that was taken into account in terms of it. It's more the risk assessment. You look at the risk associated with those properties.
But no solution?
Once the risk flags up as there being a risk of sufficient magnitude, then that's when the mitigation measures are employed. If you have no receptors and no risk, and there's nothing within the vicinity, then there would be no requirement to include all of the mitigation measures that are set out in the Code of Construction Practice. So that's the sort of next first step is to look at the risk, and then if there is a risk within that 350 metres, it's then to employ the mitigation measures.
The person assessing, is it fair to say that the person assessing the risk would look at this map to make the decision on what
No,
would
I
need
don't.
assessing?
No, the map is is used really for presentational purposes to get to so that the reader can understand what has been included within the assessment. The person making the assessment, as I said, they will normally have, I can't remember the exact term, but they get address information, and that enables them to do the assessment based on that. But it's not the, it identifies the residential property, and then from that you can make the assessment. This is, I think I've just said before, it's mainly, this is pictorial. It's meant to convey.
Colouring in.
Effectively, it's a way to show distance bands. It's very common to show them like this, but I do acknowledge it is quite difficult to see the detail beneath that.
And then there is nowhere in your reports that has got an accurate map.
I mean, it's an accurate mapping so far as it's
accurate. What do we call it?
It's an ordnance survey
Construction dusk assessment.
It's an accurate map as far as it is an ordnance survey base with an overlay of the order limits and then distance bands of 20, 50, 100, 200 from there. Yeah.
Okay, thank you. In your evidence to Mr. Henderson, you said that our property was a good distance from the bus route and construction boundary. We've said my garden's 50 metres and my house is 80 metres away. As you confirmed in your evidence, you also said that it's nearing the outer edge. The Institute states that receptors of within 100 metres will be most likely affected by dust. Why do you disagree with their guidance?
I'm not disagreeing with the guidance at all. I've talked about the order limits. So we've talked about the 55 metres from the order limits to the to the curtilage of your property. We've talked about the 81 metres from the order limits to the nearest facade of the house. Most of the activity would be centred more centrally because they are essentially the first 10-15 metres are going to be sort of landscaped rather than ultimately hard surfaced. The haul roads would be possibly out on the edge of 100 metres from your actual property. So that's principally why I was talking about that. And then I moved on to talk about the rapidity with which pollutants can decay over distance, describing that curve where they can be quite elevated very close, but they do diminish quite quickly away from the source.
Mr. Burford, can I just check how you're doing?
I am.
I know you gave an initial time estimate of about 20 minutes. Which...
Oh, okay. I shall speed it up as best I can.
Have you got much more to ask?
2 or 3 pages, yes. If you give me 1 second now. Yes. Given the topography, wind direction and speed, up to 50 HDVs passing my property on a dusty road for 55 hours a week for approximately 6 to 12 months, I'm sure if you applied your professional judgment, you would conclude that given the close proximity, there is nothing that can be done to satisfactorily mitigate the effects on my property from potentially lethal PM 2.5, PM10 and other harmful chemicals. Do you agree with this statement?
No, I think we've talked about the risk, unmitigated risk, and then we've moved on to talk about the measures that can be taken to minimise that risk. And they include all the measures that we've spoken about. they include the monitoring, they include the response mechanisms that are available. So I'm sure, given the situation, there will be a lot of consideration about what actually happens within, I said about 130 metres of the length of that area that falls within 100 metres of your property, and very much developing something that responds to those needs. So no, I think I accept the prevailing wind. It comes from the southwest predominantly, but there are several factors that mean that the mitigation measures, I think, will be successfully employed. And it's about good site management, but also having the controls, the mechanisms in place to enforce those.
I've listened to evidence about, while I've been here, about bats will have hopovers so they don't fly over double-decker buses, newts that have had bridges built for them, and even mammals with tunnels. Do you not think, and they've all been done prior to this application, why are human beings given, in the case of a human being, why is that not assessed before the application goes? Just like you've assessed the fact that, yes, there are bats, yes, there are newts. You've put mitigation in to avoid, or to maintain their health, if you like.
Yeah.
Why is why are the precautions to protect human medical conditions not put in place in line with these?
They are. It's probably, as you say, there's been a lot of discussion about various protected species, and what's been principally talked about there are the operational mitigation measures. So they are the things like, there might be culverts, there might be planting, there might be bat hopovers. They are things that are operational matters. When you come to, when you are on site, you'll do pre-construction surveys, and then you will obtain a license, and then there'll be temporary measures that will be required to make sure that you effectively aren't breaking the law with regards to those protected species. And then I could apply the same with regards to construction, dust and impacts on humans. That is, the detail comes through the contractors and their work and their proposed programme. And in the same way as there's a sort of unknown around how construction will work, which is managed through licensing and so on and so forth during the construction phase, in the same way we have the code of construction practice, we've got the local environmental management plan, we've got sign off from the local authorities, and then we've got monitoring. So I think there's a difference between construction, both from ecological human perspective and from operation, when there's more certainty about what those fixed measures would be. By the same token, we've got detailed drawings of cross sections from your house about the final arrangements. But obviously it would be very, very difficult to put in something about the temporary arrangements as they move and shift through the construction programme. So there is a difference, is why we have a code of construction practice, and it's to set those safeguards, because there are inevitably unknowns, both with managing protected species, with impact on humans, and so on and so forth. So it very much responds to that, recognising there's an uncertainty through the construction phase. So we have protected species licensing for ecology, we have environmental management plans and so on to manage other issues for the population.
Clearly. In your air quality report, you state at 3.1.2 that PM and PM10 and PM2.5 particles are small enough to be drawn into the lungs during breathing, which in sensitive members of the public could have a potential health impact. Agreed?
Yes.
Why then in the human health report, does it state that the effect on those with cardiovascular and young lung conditions will be neutral?
Again, it's taking into account the human health report that is effectively a summary of the different noise, air quality, other impacts, and it brings them together and looks at the impact on human health. But effectively what that is doing is taking the findings of the CD111, so the air quality technical report, and taking the findings of those and then applying them, looking at the sort of totality of effects on the human population. So the source is principally the air quality technical report, and that, as we've already mentioned, it does the dust risk assessment, and then it looks at the mitigation measures, looks at the likelihood of those being employed, and concludes that it's not likely to be a significant effect on human health.
Sorry. I'm trying to. I've lost my place. But,
Are you nearly there?
yeah, I am nearly there, sir. I'd just like to just finally ask, PM 2.5, there is no prescribed distance that these can travel because of various conditions.
Yeah.
But you agree that when you gave your evidence, you suggested that dust just plumes up and it drops where it pretty well starts. That is wrong, isn't it?
It's not in the round because often the almost every sort of decay curve that you look at for a lot of pollutants decays very quickly. Different pollutants do behave differently, and that's why it's actually very difficult to find any reliable. For example, the Institute of Air Quality Management and the Design Manual for Roads and Bridges, which are the sort of two go-to documents, don't really present any distance bands for different pollutants over time. What they do is then draw on, they look at the risk and then they draw on the mitigation measures, which we've already talked about. So yes, it's very difficult. Things do in the round decay quite quickly away from the source. And the Institute of Air Quality,
the larger particles?
Larger, and I think that's why we're talking about things like dust suppression, sorting things out at source, and barriers, and keeping and only confining works to certain areas will mean that the controlling it at source is sort of the best place to be, and it would mitigate. It would play a large part in mitigating those impacts. But I do agree with you that it is difficult, and it's why there's not a lot of literature out there really which actually presents the results of this. So equally, it could be quite a long distance away and have a similar effect, but in the round, it does decay quite quickly with distance.
And finally, sir, when you referred to the mitigation hierarchy, you said that high value, high sensitivity means that you would avoid, when you were talking about the SSI would.
That is that's a sort of general mitigation hierarchy principle, and I think I was just employing that in a way there where really I was saying that there are measures like fencing and things like that, what can be done to help avoid these impacts.
I put it to you that my wife's life is high value, her sensitivity to particles and emissions is high. So would you agree the best option is to avoid?
That, which I believe that through the dust risk assessment and the mitigation measures that we've talked about, that it will be avoided.
Thank you, Mr. Saunders. Thank you, sirs. I apologise for overrunning.
Okay, Mr. Buffett.
Mr. Saunders, I've got a few sort of follow-up questions there. And it may well be that some of these are perhaps questions for colleagues. So in terms, you were talking about specific mitigation measures in the vicinity of Mr. Burford's property, and you mentioned one of them would be to put the Hall Road, which, as I understand it, is effectively the construction access to the south of the carriageway. What is the mechanism that would provide for that? Do you know? If you don't know, that's fine. But what's your understanding of how would, if the Secretary of State made the order with the Dean Planning Commission, how would it be made sure that the Hall Road is sited there?
I may need help from others, but I'd imagine through a condition or something, or adding to a condition.
Right. Okay. And that's fine. If you don't know what the actual proposed mechanism, whether that would actually come through a detail from the construction, the construction management plan. In terms of citing the Hall Road to the south of the carriageway and other sort of mitigation measures, has that actually been taken into account in the ES in terms of mitigation, or is that just some detail you've added to it?
It's not been taken into account. No, the ES has just looked generally at their view of the amount of vehicles tracking along within the order limits.
So just bear with me, I'm making a few notes. Mr. Burford sort of mentioned reasonable adjustments. In general terms, normally if particular issues are brought to your attention, how would you normally deal with those? My understanding to a lot of the answers you gave to Mr. Burford's questions was that that would be dealt with in detail once a contractor's appointed. From your experience, is that normally the case, or are there things that are done? I think Mr. Burford used the phrase proactively before they get to that stage.
Yeah, I mean we're taking the idea is to take the Code of Construction Practice and turn that into the local environmental management plan. And the reason it is a local environmental management plan is it can then respond to local issues that may be appropriate to one administrative boundary but not another. There has been engagement with Mr. Burford, and I'm sure that would continue. When contractors are on board, they would have an environmental management plan coordinator or similar, and they would be that sort of point of liaison typically. And then in drawing up the environmental management plan, and there is a dust management plan that is also proposed, that would very much be worked with the local authority to, for example, determine monitoring locations, duration of monitoring, response mechanisms, and so on and so forth. So they are set out in the draft Code of Construction Practice, but there are they include those monitoring as well as those mitigation measures. I think it's in 5.2 of the. I think that would be from. Just a minute, let me just check. Yes, it's from the 5.2 PDF page 27 of CD 126, which is the draft Code of Construction Practice. That also includes the monitoring activities as well. So, it's very usual to agree monitoring positions based on sensitivities of properties, and then carry out routine monitoring and audit and so on and so forth, and reporting as well against those.
And just on that point, you mentioned that there would be a sort of an environmental management plan coordinator.
Yeah.
and again, it may well be it's in the document. But where's the specification of the role of that person?
I don't know if it's necessarily prescribed here, but typically it's written into the employer's requirements and would require a chartered environmentalist or similar. That person could cover a broad range of topic areas, but in terms of doing any, it's very normally you would have somebody fronting it, but behind that you would have specialists. So for example, dust management plan will be prepared by a team that's the air quality team, has people who are members of the Institute of Air Quality Management. If there's a noise management plan, Institute of Acoustics, and so on and so forth. So the environmental management plan coordinator would front it, but any detailed plans would be drawn up by the various specialists.
And again, this may well be in the information somewhere, but if you can just tell me. And so the LEMP coordinator, in terms of their in terms of their appointment. Sorry, I've just distracted myself. I think thinking I saw a reference, but I didn't. Sorry, yeah, that coordinator. Who would actually sort of employ them? Would that be the contractor?
Yes. Yeah.
And in terms of actually their detailed brief, is that something that, in your experience, a contractor, when bidding for work, would come to you with a proposal, or is that something as the, as the client, that specification would be provided to the contractor?
The client usually provides a specification. It might be years of experience, it might be membership of particular organisations, and then it's normal for when tenders are assessed to look at the CV of that person and take that into account in the tendering process.
Okay, and just so for the avoidance of doubt, that where in the in sort of the documentations before the inquiry is that role set out, or that expectation set out? Again, it may well be that there's somebody else to answer that. Maybe
So just to be clear, you're asking about the role of the coordinator under the
LEMP coordinator, yeah.
Okay.
Again, Mr. Saunders, I'm conscious that the applicant's got a number of witnesses covering different things. It may well be this is a question that's more to do with sort of planning or conditions.
Yeah. Yes, I can't take you to it.
Mr. Saunders, I think the applicants have probably noted my question there, and that's perhaps something.
That's fine. I'll do it in re-examination, so it's straightforward here.
So I think, and in terms of your experience of that LEMP coordinator role, would that be the same or different from sort of community liaison role?
It's sometimes separated, sometimes the same. I've worked in the capacity as an environmental management plan coordinator, and then there's been a environmental liaison officer or similar. But as projects move on, and so business as usual comes to pass, often that role morphs into or becomes one as the project runs through its lifetime. So I don't know all the details and how this might play out, but yeah, sometimes starts off separately at the early stages, but then can change over time.
And again, just the same question I asked before. Is that something that's specified from the client side, or is that something that would be provided as a response by a contractor?
It's typically a client-side and employer requirement.
Right, it's 5 to 11, so I'm going to take the mid-session adjournment now, rather than wait until Mr. Saunders has finished. We'll, given that this session's taken a little bit longer than originally anticipated, I'll just take a 10-minute break. The inquiry is adjourned and we'll resume at 11:05.
Thank you. Mr. Saunders, again, Mr. Burford asked you about how, I think in some terms, how you can be sure about the effects on particular properties. Now, I notice in the technical report, I think CD 11102, which I think is the one we've been looking at. The nearest receptors are, I think, a property that's in the same area as Mr. Burford, but actually one that's much closer to Madingley Road. And I think the other nearest one is probably the farm where you mentioned the National Union of Farmers offices. I mean, given the location of those two receptors, I mean, how have you been sort of certain about what effects are likely to be on properties such as Mr. Burford, which are sort of much further from Madingley Road and closer to the route?
Yeah, I think it's receptor 100 that's the NFU one, and that is a proxy really, I think, for the jungle as well, so Mr. Burford's property, similar distance. I think from an operational perspective, then the results show an improvement over time, and that's actually just a function of emission controls in the future. So therefore, operationally, air quality will improve at comparable properties due to those emission controls in the future. From a dust construction perspective, then that's been much more down to the risk assessment, the proximity of the property, and the control measures as well. So whereas, yes, receptor 100 has been used as a proxy, if you like, for that area and shows some benefits with time, then during operation for construction dust, it's been much more around properties within those distance bands and risk, and then applying mitigation measures.
And when you say that there will be improvement over time due to emission controls, is that from pollutants coming from Madingley Road?
Yes.
So in terms of the any sort of emissions coming from the operation of the busway, how does that factor in?
Yeah, so it is included in the modelling. Overall, the flows along the busway are low. The intention is obviously there'll be fully electric at some point as well. So there would be no emissions as such from a tailpipe perspective. So yes, it's principally about those flows along Madingley Road, where you may have a slight increase in traffic over time, but that would be offset by the vehicle fleet being more composed of electric vehicles.
And just talk about electric vehicles. I mean, I think you're saying that the intention is that all buses using the route would be at the highest emission standard, which I think you say is currently Euro 6.
Yeah.
And I think there's a proposed condition to try and do that. I think then the technical report goes on to say that there would be improvement with electric buses. But can you just clarify in terms of what the ES assumption is? Does the ES assume that that effectively permanently it would be Euro 6 buses?
What it would normally do, and probably rehearse this a little bit with greenhouse gases, is that it would use DFT or forecasts to look at how the fleet changes over time. So typically you would take a worst case, but if there are factors, that DFT factors, etc., about fleet, you would apply those into the air quality model. And it's very usual for worst case to be the year of opening for air quality models, and that's because even though there might be traffic growth over time, the vehicle fleet would change in composition and way much more in sort of favour of electric vehicles over time, which is why with these results, the year of opening has higher levels than I think it's 2040, where there is a 20 or 30% reduction in emissions in the future.
But But in terms of the ES, it's assumed that worst year, it's that worst case scenario,
Yeah.
and it's not. So is it relying on the fleet mix to change to partially electric or all electric at some point?
Yes.
Or is it? It is.
Yeah, in time. Yeah, so it would look at that proportion over time. Yeah.
And it is the assumption that that will just happen out with any controls within the proposed scheme, rather than in terms of the Euro 6 standard being a sort of a minimum. There's a proposed condition for that. In terms of the over time electrification of the bus fleet, the assumption is that would just happen rather than there's a requirement to happen. Is that?
Yes,
I got that correct?
Yes, I believe so. I think the air quality modelers do use the emission factors they're presented with, and yes, as you say, they would use those.
So if the fleet mix didn't change as anticipated, what are the implications? Does that have any implications on the findings of the ES?
No, because the findings are that with time the things would improve, but even in the year of opening, which is the worst case, the levels of nitrogen dioxide, of particulate matter, PM10 and PM2.5, they would be well within the air quality objectives in any event. So what it might mean is that there might be less benefit in the future than currently shown, but notwithstanding there would be a benefit.
And in terms of, again, you mentioned that so, and I'm talking about sort of operational. You see, you mentioned in terms of the general approach that it wouldn't just be a case of agreeing particular mitigation, but there would be monitoring. What monitoring is being proposed over time in terms of air quality for the operation of the route?
The monitoring I've been talking about is related to construction monitoring. For the operational phase, I don't believe there's any bespoke modelling, but the local authorities do have their own monitoring stations where they can look over time at how things are working generally through the network.
So from your understanding, the intention is that the mitigation would be put in place, but that not necessarily in terms of air quality there would be anything other than what the local authorities may do now or in the future.
Yeah, and because I think that principally comes down to the obligation to consider monitoring where you've got likely significant effects, and no likely significant effects are predicted through operation due to air quality reasons. So there's no need to consider monitoring on a scheme level.
And is that a principle across the proposal, that it's only where there's likely significant effects that you're proposing for there to be ongoing monitoring? Is that?
Well, it's the EIA rules, regulations that really require. It's not to say that at a project level things that there isn't sort of, if you like, over and above monitoring, but yeah, the EIA rules, regulations require that if you do conclude there are likely significant effects, then monitoring should be considered. And it doesn't happen in every case, but it's a consideration of that.
Thank you, Mr. Sawes. Whilst I've got you, I have just got a couple of clarification points about a different matter, but I'll let Mr. Clegg ask some further questions probably on the air quality. Thank you.
Yeah.
Mr. Saunders, just coming back to a point that you made in relation to an exchange with Mr. Underwood. When you were talking about the effect of the scheme being well within the air quality objectives. I think you said that there may be less of a benefit than is shown, but there would still be a benefit in terms of emissions. Do you really mean that the scheme would give rise to a benefit, or just that there'll be less harm, or that
The scheme overall in the round
Yes.
gives rise to an overall benefit in air quality. But the principle really is around in the future. It's almost out with the scheme. Is that emission controls would dominate as a way of improving air quality levels over time.
but emission controls would be separate from the scheme?
Yeah, sorry. I'm talking about the predictions that have taken place at the properties, and they show that they take the scheme into account.
Yes.
But the main factor is actually just generally emission controls.
Are you actually saying that the scheme itself could give rise to a benefit in terms of air quality?
I'm saying in the modelling, the scheme itself is obviously overall it's part of the mix in the modelling. The scheme
Yes,
is
I
accounted
understand
for
that.
it.
But if you just look at the scheme, what's happening, the busway with the vehicles running on it?
Yeah, so that would take into account any removal of traffic from the
Yes.
road. So the modelling takes into account call it the affected road network. So it looks at with and without busway proposals.
Yes.
Obviously, if there are some non-electric buses at some point, you will be putting some non-electric buses
Yes.
close to some receptors.
Yes.
And so there'll be some receptors, and I think they're the receptors that we gave you some clarification on
Yes.
as to where they might have some marginal changes. But then looking at in the round across the whole affected road network, then we see there's an overall benefit if you model traffic changes, the buses, and so on and so forth.
Okay. I'm just thinking of your mitigation measures that you mentioned a little while ago. How could the form of boundary treatment affect air quality?
So,
And is it only boundary treatment? And you've mentioned boundary treatment or structures that could go near boundary treatment in the form of fencing, I think. Is that the only form of boundary treatment that would be effective?
so for the construction phase,
Yes.
I'm not sure that would be the only one at the boundary. It might be, for example, you could temporarily seed areas or just let them regenerate, because that cross section within that area, there is ground that is not potentially immediately required, or there won't be a lot of work taking place at it. So I'm talking about that intervening area of land between where the busway itself would run and the order limits, where there is a strip of land. And so there could be, it's not uncommon to either leave it. If you don't need to touch it, you don't
Yes.
touch it. Or seeding. There are measures like that could be employed, and they obviously prevent dust close to the boundary.
And even an existing boundary with the property, there is screening and tree cover.
Yeah, so
How effective might that be?
I think it's better to have it
Near source.
at source,
Yes.
yes. And I think that would also that would also chime with the
Yeah.
Institute of Air Quality Management guidelines, where they talk about barriers close to the
Yes.
source.
Well, you made the point about pollutants decaying rapidly as well, and things happening at source.
Yeah.
But do barriers at a greater distance than source have any benefit at all?
I'd find it difficult to say that. I know it's something that might come out of a dust risk assessment.
Yes.
So it might be. We've talked about the difficulties sometimes with predicting
Yes.
how dust might behave and
Yes.
distances and so on. But yeah, it's more common to have an enclosed
Yeah.
fencing or something close to the source within the order limits. That's most effective.
Okay.
And then carry out the monitoring at any properties, and then see if there are any issues, including there's a commitment to carry out some baseline monitoring, I think 3 months in advance.
Yes.
So you effectively get the baseline, but appreciating there will be seasonal differences, including
Yeah.
any ploughing, etc., or harvesting that might take place on the land as well. So
Yes, but the key thing from your point of view is barriers close to source.
Yeah.
Thank you.
Okay. Whilst here, can I just ask a sort of clarification point about just a couple of things on water and flooding? Because I think, if I understand correctly, Mr. Southern's dealing
Yes.
particularly with the Bin Brook and not the wider scheme, whereas you were talking about water issues and flooding elsewhere. Is that correct?
Only insofar as I covered most of the environmental topic areas that weren't covered by specialists who were addressing those because they'd been raised by other parties. So if I can help, I will.
Well, being specific, I mean, are you able to answer a question about the Water Framework Directive?
No, I don't think I would be able to.
What's the query? So
Yeah,
if you want to ventilate it, we can then...
Yeah.
I mean, I've got some detailed ones here. At the heart of it is you've provided a water framework sort of screening and scoping assessment, and the conclusion of that, I think, is that that there shouldn't be an issue in terms of compliance with the Water Framework Directive regulations, but that it's going to have to wait as part of a Stage 3 impact assessment, which will be further down the line. What I'm trying to understand is, given the duty that the Secretary of State has under the regs, is that enough for the Secretary of State, if the Secretary of State were minded to grant the order, that in effectively leaving it to Stage 3 further down, is that going to be enough so that the Secretary of State could reach a finding on the effects on the water quality? And I think it's largely Bin Brook, but there is also the other river, whose name escapes me, which has two different names. I think the old West River or something. I can't remember. That's the one that starts up near Scotland. That's the one, yeah. And I'm conscious that the Environment Agency, from what your conclusion says, appear to be content with that, and no doubt the Secretary of State will take into account what the Environment Agency say. But that was effectively what my question is. Given that the conclusion of the screening and scoping assessment is effectively that I think that there are unlikely to be risks, and that it can be designed out or mitigated during the detailed design phase, whether that's going to be sufficient for the Secretary of State to reach a finding on that, given that it effectively waits to the detailed design stage.
I suspect it's you've been satisfied, which we can come back to, that the controls are in place to do with that. But we've noted the point that Mr. Saunders can't deal with it. You'll get back to you on that. And we'll do so this week. So you don't have to before we break.
Thank you. Yeah, and just so I'm clear, so in terms of water framework direction questions, I'm assuming that's outside Mr. Southern's.
He won't be telling you about the water framework direction.
Right. Yeah. Is there a witness who deals with it, or is that just something in evidence that you don't have a witness on? Just so I understand.
Well, we haven't intended to call a witness on it, so because no one has asked questions. If you've got questions that go beyond this one, which we I'm content to respond to you in writing this week, and if you want somebody, then tell us now, please, and we'll find somebody.
I'm not asking somebody, I just want to know whether there is.
We're not intending to call anybody
Thank you.
else to deal with water or flooding beyond Mr. Southern's action.
Thank you. Just another clarification on the on flooding in terms of the National Planning Policy Framework test where the exception test has two limbs. Again, is this a question?
You're going to hear about that, sir. Mr. Sutherland's going to give you all the facts about making things safe in the environment. Mr. Sensible will reply also.
Right, so that's a Mr. Sensible question. That's fine. In that case, those are all the questions I've got. So thank you.
Thank you.
Over to you, Mr. Henderson. I think.
Yeah, great. Can we go back, please, to CD 11102, the technical report? Can you go to PDF page 13, please? And on PDF page 13, you have the subheading sensitive receptors at the bottom. Do you see that?
Yes.
And if we look at this paragraph, a construction dust risk assessment is undertaken where there are, (1), human receptors within 350 metres of the site boundary. Do you see that?
Yes.
And it goes on to explain other receptors, those 50 metres of the route, etc. And if you look at the end of that paragraph, which is on the next page,
Yes.
the construction dust assessment study areas are illustrated in Figure 1 in Appendix L, which is where you were taken to by Mr. Burford. So can I ask you, with that introductory text, can you go now, please, to Appendix L and PDF page 106? And first question, can you identify for the inspectors, please, the 350 metre buffer referred to in that paragraph on PDF page 13 that we've just looked at?
Yes, the bluish shading. Obviously, that is the bluish shading is the 200 to 350 metre zone.
But by reference to that 350 metre study area, and having regard to St Neots Road, how far to the north does that 350 metre study area extend? Is it on the south side of St Neots Road? Is it in the middle of St Neots Road? Is it on the northern side?
The northern side.
Right. So what proportion of Mr. Burford's property is within the 350 metre buffer zone that you've identified on the plan?
That would be all of it.
Right. So for the purposes of page 13, PDF page 13 that we were looking at a moment ago, if you go back there, 3.16 at the bottom,
Yeah.
having looked at that appendix, was Mr. Burford and his wife a human receptor within the 350 metres of the site boundary and a sensitive receptor for the purposes of your methodology here?
Yes.
And what did that mean in terms of the assessment made of Mr. Burford and his wife as sensitive receptors?
That means that they would have been taken into account.
Right. Does any of that change depending on the precise distance within the 350 metres as to whether you're in the dark green, the light green, or any of that? Does any of that change whether or not they were receptors, sensitive receptors, taken into account, as you just said?
No, all within 350 metres would have been taken into account in carrying out the assessment.
Next point here deals with that which is mitigation, and you were asked a question by the inspectors about some of the measures, the bespoke measures that you've referred to, and whether they were included within what has been presented to date, and you explained that they were additional. Having regard to that answer, what does that mean in terms of how precautionary or not the assessment presented in this technical report was? If those were excluded.
So the measures are the Institute of Air Quality Management measures. They in essence are precautionary in that there are a lot of measures. The additional measures are the ones that could be made bespoke, but they are very sort of additional detail at a local level.
And if that additional detail is added in,
Yeah.
what does that mean for your confidence in the robustness of the conclusions reached within the technical report?
It would give greater confidence.
Right. Now, the next point from one of the inspector's questions was about point 100 receptor 100, identified 100.
Yeah.
Just let's put that in context, please. Can you go forward to page 17, PDF 17,
Yes.
in this document? And just so do you see the subheading selection of sensitive receptors?
Yes.
And do you see 3.2.24 at the bottom of the page?
Yes.
All modelled receptors included in the assessment are shown in figure 3 in Appendix L, and details of the modelled receptors are provided in Appendix H. The modelling referred to here, if you just turn back please to PDF page 14, you're able to clarify, it says operational phase. Is this operational phase monitoring, or is this construction and operational phase monitoring?
This is operational phase assessment.
So in terms therefore of the construction phase, is the approach that you've already explained by reference to 3.16, or is it some other approach?
No, it's that approach.
Right. Now let's deal please with the question of conditions. Can you please pick up CD 2912, which is, there's a slight update to this, but it's not relevant for present purposes. The statement of common ground with the local planning authorities and the updated set of conditions following those discussions. And go please to PDF page 12 within CD 2912.
Sorry, Mr. Wilson, the page, please.
Yeah, 12, sir. PDF 12.
Page 12.
12.
Just loading. Yes, I've got that.
Now, let's just take it slowly. No development shall commence, including intrusive site investigations and demolition, until a development phasing plan setting out the sequence of delivery of the development has been submitted to and approved in writing by the relevant local planning authority. The development phasing plan must include a proposed sequence for providing detailed design of the following elements and areas, including, where appropriate, the securing of additional detailed plan permissions. Do you see number 3, enabling works, e.g. Hall Roads? Sorry, number 2.
2, yes.
Yeah, and if you turn over below Roman 5, the development phasing plan, so that's the plan we've just been referred to, shall identify, do you see B, the location of the proposed site compounds, including temporary Hall Road arrangements?
Yes.
Do you see that?
Yes.
So, having considered this condition, the question the inspector asked you was about whether or not the location of the Hall Road to the south had been secured. In light of condition 3, is there a mechanism for securing that more southerly layout of the Hall Road?
Yes, so that approval in writing by the relevant local planning authority to that plan.
Right. Move forward, please, to PDF page 16. And do you see
Yes.
condition 8, Code of Construction Practice?
Yes.
Prior to commencement of development, a Code of Construction Practice shall be submitted to and approved in writing by the relevant local planning authority. The Code of Construction Practice submitted for approval must accord substantially with the draft Code of Construction Practice, document reference C2C 2600. Now, pausing there, is that the same draft that you referred to as CD 126 in your evidence
Yes.
this morning? So in light of that, to what extent, in your view, is compliance, in broad, substantial compliance with that draft, secured by the conditions that have been proposed?
Yes, again, it's approved in writing by the relevant local planning authority.
Right. Now, to think about some specific measures within that, can I ask you to go down, please, to 9, local environment management plans? Do you see that?
Yes.
No phase of development, with the exception of site investigation works approved under condition 4 and archaeological mitigation work approved under condition 7, shall commence until a LEMP, a local environmental management plan, in relation to that phase has been submitted to and approved in writing by the relevant local planning authority in consultation with Natural Inland. The LEMP shall cover all matters specified in sections 4 to 13 of the Code of Construction Practice approved under condition 8. Do you see that?
Yes.
Go now, please, to CD 126, the draft COCP. Within that, please go to PDF page 22.
Yes.
Sorry, PDF page 27. Sorry, PDF 27.
Yes.
It's internal page 22. My error.
Yeah.
Do you see 5.2 monitoring of air quality?
Yes.
Can you look at what 5.2.1 says, please, and remind yourself what is there?
Yes.
The monitoring of air quality during the construction process, having regard to condition 9 and then this part of the COCP, part 5, to what extent is that monitoring secured by the conditions proposed?
Yes, it's they do secure that condition and requirement.
Now, just bear with me. The other component part of the COCP, can I ask you to go please to PDF page 9?
Yes.
Do you see supervision?
Yes. 2.5.
Yeah, and remind yourself please what 2.5.1 says.
Yes, I've since read that one and realised that that's in relation to the qualifications of the type of person who might be, for example, an environmental management plan coordinator.
Yeah. So would that secure the sort of coordinator that you referred to in response to the inspectors?
Yes, as I say, suitably qualified and experienced. I talked about the types of qualifications and the duration of that of experience. So that would be a very sort of typical requirement.
So having regard therefore to conditions 8 and 9, to what extent is the appointment of such a suitably qualified person secured by the conditions proposed in order to manage the LEMP?
Yes, that is secured.
Sorry, Mr. Hennis, can you just give me the paragraph number?
Of course, sir. It's 2.5.1, and it's the first sentence in particular that Mr. Saunders directed your attention to, and that's on PDF 9, internal 4.
Thank you.
Final set of questions about buses and modelling. Back please to CD 11102. And go please to PDF page 5. And this is the introduction summary.
Yes.
Now, you explained about the use of DFT data for fleet composition generally, but I just want to ask you about the buses specifically, so the buses on the scheme. Can I ask you to look at paragraph 1.1.6 and remind yourself of what is said there? And in light of that, can you explain to the inspector, leaving aside vehicles, fleet mix generally, but specifically about the buses running on the scheme, what assumption has been made about the buses for the purposes of the modelling in this technical report?
Yes, as it says there, it's a worst case for those buses.
Right. So has the assumption of those buses been based on some transition to electric vehicles at any defined point in time for the buses specifically?
The buses specifically, no.
Now, that takes us on to the second point about the modelling of the buses, and you explained to Inspector Clegg that with the modelling, you said there'd been modelling with and without, and that shows, in your view, a benefit as a result of the scheme. Just want to look at that, please, now. Same document, go forward, please, to paragraph 3.2.5, which you'll find on PDF page 15.
Yes.
And we get, for the assessment, 3 scenarios were modelled as follows. Which of those 3 are the relevant ones for this issue, for comparing the with and without the bus?
The do minimum versus the do something.
Right. So that's the second and third bullet points. Now, in terms of what that then means for the modelling, can you move forward to PDF page 31?
Sorry, can I just clarify what your answer was there, Mr. De Saunders? Were you saying it's both do minimum and do something?
I did, yes.
Yeah, they're the 2 to look at, so and we'll just look at that now. PDF page 31. Do you see this heading summary of likely significant effects?
Yes.
And this explains the overall conclusions. I ask you on this specific issue to look down to 6.1.4, please.
Yes.
The C2C scheme will encourage modal shift and improve air quality. This has been demonstrated by the assessment. The model results show that 3 times as many receptors would experience an improvement in concentrations of NO2, PM10, PM2.5 respectively when compared to the assessment without the C2C scheme. So just help me. The assessment there, with and without, how does that correlate with the bullet points that we've just looked at a moment ago?
Yeah, so it shows that with the scheme, there's an overall benefit of the magnitude that's described there.
Right. And going back then to PDF page 15 and the 2 bullet points that you identified, 3.2.5 bullet point 2 do minimum and bullet point 3 2041 do something.
Mm-hmm. Yes.
The bus changes, the bus goes in to the do something and is left out in the do minimum. Are there any other changes between those 2 assessment scenarios?
No.
So in light of that, to what degree can the positive effects that are identified at the end of the report be isolated down to the busway's installation?
Yes, well, the results that are shown later on in the report are basically without the busway do minimum and the buses, and with the buses in the do something scenario, so that 3rd bullet point. So that overall benefit purely due to the busway.
Great, so they're my questions.
Thank you, Mr. Saunders.
Thank you.
Yeah, that's fine.
Just so I wait, in terms of my query about the Water Framework Directive, I think probably what I'll do is actually just write a written question.
Of course.
Just so that
that'd be very helpful.
Clear what we want, and I'll send it through to you.
Yeah, and we'll come back to you this week.
Thank you very much.
And as Mr. Saunders leaves the scene, we'll have Mr. Wilson.
Mr. Wilson, sir.
Yes. Now, when Mr. Wilson gave evidence previously, that was prior to Clare Hall having withdrawn their objection. So the understanding was that the heritage interests around concerning Clare Hall and the immediate vicinity were in effect left to the recall of Mr. Wilson. So evidence hasn't, as we understand, it's essentially been led in chief on those matters. So we'd invite either yourself, Mr. Cameron, or Mr. Henderson to do that with Mr. Wilson.
It's going to be me, sir. We're going to stick to Clare Hall and immediate vicinity, and in effect we're just going to draw your attention to where you find the assessment in the evidence, and then we're not planning to go into enormous detail. So, Mr. Wilson, if you're in position, you have already been introduced to the inquiry. You're Thomas Wilson, and you're an associate director at WSP, and the inquiry's already heard about your qualifications and experience.
That's all correct, yes.
Thank you. Right, well, let's go. We're actually first not going to go to Clare Hall, but with permission, we're just going to deal with Conduit Head Road Conservation Area, which is another point. So if you recall, and the best way to deal with this is if you can get up core document 11107-1. And when we've let me just check I've got this right, it's the technical report 7 on heritage. It's 1-11-07-1. Not very snappy title. And this is where the issue arose. I was just going to go back to remind you, sirs, we had, and on page 160 of that document is a map which shows the West Cambridge Conservation Area, but it doesn't show the Conduit Head Road Conservation Area, and I can't remember whether it was Mr. Clegg or Mr. Underwood who pointed that out, but one of you did. So Conduit Head, Mr. Wilson, you better just identify for the inspectors where Conduit Head Road is on that map. I think it's marked so we can all read it. But
Well, we have a revised.
well, could you just show on that map, please, was the question,
Yes.
where Conduit Head Road is. I didn't ask where the conservation area was.
Conduit Head Road runs north from Manningley Road to the north of High Cross.
Yeah.
Thank you. So you will recall, sirs, that you said, wait a minute, isn't there a conservation area there? Not shown on this map. So that's just where I wanted to go to there. And then if we can go to where I think you'd like to go, which is core document 2986, which is environmental statement addendum 3, please. Just wanted to do that just to remind you of how this point cropped up. So if we can now go to 2986. And if we go to page 52 in that document, we find a heading, Conduit Head Road Conservation Area. And I think if we go to page 54, do we find a map which shows where it is?
Indeed, yes. This is a revised map showing the location of Conduit Head Road.
So that's page 54, so we know where it is and its extent. And then if we go to pages 52, 53, do they include an assessment of the impact of the scheme on the significance of that conservation area?
Yes, they do.
And what was the conclusion that you came to?
The conclusion was that there was no impact, or there would be no impact on the conservation area as a result of the scheme.
Thank you. Don't intend to ask you any more about that. Can we go to Clare Hall now, please? And if you take up your proof and go to page 25, and we find a paragraph 4.4, which has statement of significance. And when you gave evidence before, you referred to the National Planning Policy Framework, to the definition of significance in relation to heritage assets in the glossary.
Yes.
And in this part of your proof, 4.4 and then 4.5 when you're dealing with setting, is this where we find your assessment of the significance of the listed building?
Yes, that's correct.
So you, again, I'm not going to ask you to read any of this out. Everybody's got it. Extensive analysis, setting, and then can we then look at 4.7 on page 31, and you've then got effects on Clare Hall, and you've covered here physical effects, operational effects, the permanent infrastructure, and operational effects of the buses. And we should note that you've taken into account, for example, at 4.7.5, removal of the line of trees along Rifle Range Road. And we should also take into account that note that you've taken into account effects on noise and vibration at 4.7.13.
Yes, and 4.7.14.
Thank you. And having done all that, and we go on to page 35, and there's a heading harm in terms of legislation and planning policy. What was the conclusion that you came to?
The conclusion was that the level of harm would be less than substantial, and it would be towards the bottom of the range. Less than substantial.
And we can see at 4.7.27, well below the middle of the range, between no harm and substantial harm, and towards the bottom of that range, as you've just said. Thank you. Can we just, while we're on Clare Hall, can we consider a different point which you deal with in your proof at 6.1.13, and this is where you're assessing any requirement for listed building consent.
Yes.
And you set out there at 6.1.13 the questions that you've posed, and what follows are the answers to those questions. But can you just take us through, perhaps the best way to do it is to have 6.1.13 in front of us, so we've got the questions, and you could give us a brief summary of the answers based on your written evidence.
Right. So 6.1.13 lists the questions, and the answers to those questions are in the next 3 paragraphs. So the first question is, are the paths an object or a structure fixed to the building? And my evidence is that the paths are not objects or structures, they are simply a surface treatment of the ground. And in addition, they are not fixed to the listed building. Moving to 6.1.15, the second question here is, do they lie within the listed building's curtilage? And if so, do they form part of the land? Now, I've explained in my proof that they are not in the curtilage for the following reasons. They're not part of the listed building's layout. They're outside the property. They're not part of the listed building's layout because they're discontinuous from the internal surface treatment, and because they are separated by a boundary wall and an enclosing structure which goes along the boundary of the listed building. In addition, They are outside the property because they have never been within the land ownership boundary of Clare Hall. That's my second question.
And these are all, this is, if the answer which you gave to are the paths an object or structure fixed to the building was no, would you have to go on to consider the next question, or have you just gone on to consider it in case somebody takes a different view?
I think that, yes, all, the latter, all considerations are given their due here. So, if they are, if a contrary view is taken that they are in fact objects or structures, we can then determine the question of whether or not they are within the curtilage. And then, if a contrary view to mine that they are in fact within the curtilage is taken, we can then turn to the third question, which I'll turn to now, which is in paragraph 6.1.16. It is, if they are objects or structures lying within the curtilage, would the works constitute either demolition or alteration or extension that would affect the character as a building of special architectural or historic interest? The first part of that is quite simply that the parts are not being demolished. The second part, if they are considered to be objects or structures within the curtilage, alteration would still have no effect on the significance of the listed building, as the paths don't embody those architectural and historic interests which lend it its special interest. And even if they did, even if you took the contrary view that the paths do embody some of those interests, the work would reduce the path's length, but they would still function as they do now, which is to run from the building to the metalled road. The proportions of the paths are not relevant. They are not an architectural consideration. They just happen to be as long as they are. And so the asset's character would not be affected by them being shorter, provided they continue to serve their function.
So if they don't, if you get past 1 and 2, contrary to your view, and you get to 3, C, if they're not demolition, and if they're not works for alteration or extension in a manner which affects its character as a building of special architectural or historic interest, do you need listed building consent?
No.
Thank you. And if we go on to the next, we've been found against us on A, B and C. Now we get on to D, which isn't there, but 6.1.17 of your proof. You then contemplate a different hypothetical position. If the paths were found to be objects or structures lying within the curtilage and the alteration of which would affect Clare Hall's character as a building of special architectural historic interest, listed building consent would be required. And then you put forward a approach to be taken in that event, which is imposing a condition on the grant or any direction that planning permission be deemed to be granted.
Yes, that's correct.
Yeah. But that's the fourth line of defence, if I can call it that.
There is also some potential, which I also refer to in 6.1.17, for retaining the paths within the detailed design.
Well, that's perhaps the fifth line of defence.
Sure, it comes back to it.
Yeah, thank you. So can we now just turn, still with Clare Hall in mind, to the representations made by Historic England, and can we there turn up, make sure I get the reference right, but it should be CD2 Rep 082, This was the second of the Historic England representations. And this should be, once everybody's got it, a letter of the 8th of August 2025 addressed to the inspectors. So this is a written representation, and we've got a slot in the programme for dealing with this, but we're going to deal with it orally here with you. And if we go to page 3, we just note at the bottom of page 3 that, as Historic England say, as stated in our January response, they consider the harm that would be caused to the designated heritage assets by the proposal taken as a whole would be less than substantial and could be weighed against the public benefits, and that they continue to have no objection to the proposals on heritage grounds. They then go on to Clare Hall, and if you go to page 4, first full paragraph, it has been brought to our attention that the deemed planning drawings are potentially misleading at this point in the proposed route. The proposed site plan, sheet 17 of 17, shows the boundary of the sea-to-sea order limits almost abuts the southern elevation of the college buildings, but is of insufficient detail to determine whether physical works to the drainage conduit would be necessary. So, would physical works to the drainage conduit be necessary?
No, there'd be no alteration to the conduit's fabric.
Thank you. And I think, just for the inspector's notes, that if we, in your rebuttal, at page 6, 2.1.15, you say that the rainwater spouts and moat channel or canal would not be physically harmed by the sea-to-sea scheme.
Yes, that's correct.
And then if we go back to Historic England, having considered Clare Hall, bottom of page 4, did they change their position or not change their position?
They are notifying that they do not wish to change their position with respect to the proposal as a whole or raise any objection.
Right. Thank you very much. That's all on Clare Hall, but as we're dealing with this is the last point, the vicinity of Clare Hall, can we just take up your proof, page 45, where you deal with the West Cambridge Conservation Area? And 5.8.4, what was the conclusion that you reached in relation to the West Cambridge Conservation Area?
That there will be harm, that is harm through alterations to character and appearance of a low degree of physical alteration, and that harm would be less than substantial harm and towards the lower end of the range.
Thank you very much, Mr. Wilson. Those are all the questions I've got for you, but the inspectors may well have questions for you.
I'd just like to sort of clarify a few of those points that Mr. Cameron took you to. Just starting off with the, I think Historic England call them conduits, but I think they're referred to as canals, the concrete drainage channel that runs along the south elevation of the
Yes.
of the Erskine listed building. You said that the works aren't going to affect that feature at all. Can I just clarify that there, at the western end, the canal feature continues beyond the Erskine building and sort of terminates with a semicircular feature next to, I think it's called the Brian Pippard building, if I've got the buildings correct. But part of that actually runs alongside the gable of, I think it's number 5, which is part of the Erskine building. And it's at that point, I think, where the order boundary sort of kicks in and includes that part of the canal. Can you just clarify, is your understanding that that part of the canal is part of the curtilage of the listed building or outside it at that point?
I go into some detail in my proof on that matter.
And by all means, direct me to the paragraphs in your proof if...
I will do my best. But I think
oh, of course, yeah.
So the canal was extended when work took place in 1997, 1998. So that section of the canal which runs west of Family Walk is not original to the building.
And so, is Family Walk, is that the name of the internal route within the Erskine building in between, next to the sort of the smaller units, which I think number 5 is the end one?
Yeah, there are 2 passageways running from north to south. The western of those is Family Walk. And I use the word canal, by the way, because that's in the list description. The canal ends at that point. In the original design. I believe when the Brian Pippard building was constructed, the canal was extended further west, as you quite rightly point out. Brian Pippard building was excluded from the listing when that took place in 2013, something like that. So in consequence, I take that extension also to be not contributory to the significance of Erskine's original design. The reason why it is, I may be preempting it, but the reason why it's within the land boundary, within the scheme boundary, is because it is within the land boundary, which follows the original layout of Erskine's building.
So just to be clear, you're saying that the curtilage sort of extends to the canal to the east of number 5, but doesn't extend to the canal to the front of number 5 going west. Is that?
Yes.
That's your view. Are there any proposed changes to that part of the canal which you're saying isn't?
Right. I was hoping that you'd ask. Because the next point to make is that although that section of the canal is within the scheme boundary, because the scheme boundary is based on the land ownership boundary, there will be no work to the canal. The canal will be separated from the construction site by fencing. There is detail about the code of construction practice, which has been submitted to the board, and there will be methods of working in place and avoid that aspect of all aspects of it.
Thank you. I think that's helped me just understand that point. And just in terms of that, you mentioned the code of construction practice and some fencing. Presumably, that's to avoid anything happening during the construction phase. In terms of the sort of more generally, in terms of the effect on the any effect on the canal, my understanding is that there is going to be a partial sort of raising of ground levels along that area, presumably going up to the edge of the canal. Is that correct in terms of a slight embankment?
There is a difference in height between the canal and what will become the metalled surface of the road. But as far as I'm aware, at the point where the ground meets the canal, there will be no change.
And again, in terms of sort of the detailed design, what mechanisms are there to ensure that what you're saying will actually come forward in the detailed design? Again, if
you mean in terms of?
Yes, sorry, you're saying that the none of the work, whether it's irrespective of it's going to affect the canal, whether it's the canal that's within the curtilage or the Brian Pippard building section of the canal,
right?
And that includes any embankment, etc. My question is just how. But I think if I understood what you're saying correctly, you're saying the details will come at the detailed design stage.
Well, there are control measures in the Code of Construction Practice, and I can get a reference for that later.
No, it was less about the construction. It was more in terms of the permanent final design.
Right, in terms of the final design. I'm not sure.
If you think it's a question for somebody else,
I think it's a detailed question on how the detailed design will be controlled, and there are mechanisms for doing that which are beyond my aegis.
Thank you. And again, just going back to the paths, and you set out, I think, in five sort of scenarios in terms of that. But my question was, your contention is that they don't form part of the curtilage. But what if they don't? What effect do they have on the significance of the listed building that it might derive from its setting with the presence of those paths in place?
They are a part of the setting of the listed building, and they do contribute to the setting in a positive way to some degree. In my assessment, I recognise that there is a limited amount of harm to the listed building as a result of changes to the setting. They would be included in that.
And again, just so I can be clear on the point, is in terms of the assessment in the ES and your assessment, is the worst case scenario that the paths will just be truncated, or is the worst case scenario that they would actually be removed beyond the curtilage?
I'm not aware of any proposals to remove them completely. My understanding is that the access track will be closer to the building than the existing metalled surface, so that will result in metre and a half, I think I have worked out from the plans, which would be removed from the southern end of those three paths.
So, yeah, so I said truncate. Yeah, cut the end off.
Yeah.
And I think that's questions I've got on the Erskine the Erskine building. Although again, actually, in terms of the again in terms of the sort of the embankment that's proposed along there, can you just clarify what your assessment of the effect of that embankment is? And again, apologies, I probably haven't got the right page in your proof in front of me.
So a strip of green is being removed and then reinstated. It is going to be slightly narrower. It's going to be narrower. I'm not going to use the word slightly. It's going to be narrower. But it's going to be still recognisably a green border just outside the listed building around its edge. To that extent, again, the setting is somewhat altered in a way which is adverse, but the general appearance is the same. The difference in height is not something which I put any weight to, as far as the listed building is concerned. I don't think it's very great, and I don't think it matters to the effect on the significance of the listed building.
So sorry, you said, can you just clarify, you said there was an adverse effect?
Because there's there are a number of things changing to the setting which result in a slight adverse effect to the significance of the listed building. One of those changes is the fact that that band of green which we see around the outside of the listed building is slightly narrower, but it is still recognisably a green border around the listed building.
So it's a slight adverse effect, but the adverse effect is in the reduction of the width of the currently green sort of area between Rifle Range Road and the canal.
Yeah, I'm not sure. I'm speaking off the cuff. That's not a capital S, slight capital A adverse. I'd have to check, because it is, as I say, part of a series of other changes which add up to the effect that I've stated in the environmental statement.
Okay. And in terms of that, I mean, just turning back to when you were talking about the effect of the CPPF scheme on the American Cemetery group of designated heritage assets, I mean, do you characterise that as the same amount of harm, or were you saying that the American Cemetery group was different? I'm conscious that we haven't got a detailed design there, and that was, I think, part of your and your colleagues' evidence about what the implications might be of a change in level along Madingley Road. But I was just wanting to understand whether you've ascribed the effects in the same sense or in a different way.
Well, they are different in a number of different ways. I don't quite recall off the top of my head what the conclusion to that was in very specific terms. We're dealing, of course, with the front of the American Military Cemetery and its approaches, as opposed to essentially a road or path around the back of it. I think that's quite significant.
If you can't recall that at this precise moment, I'm sure perhaps that could be a question that could be asked in re-examination, possibly. Just so I can understand whether there is any difference in the way
right.
It's doing it.
So you're referring to the alternative, not to the C2C scheme.
That's correct. Yes.
If you just give me a minute, I will refresh my memory, and then I'll be able to give you a bit more of a reasoned answer. Towards the low end of less than substantial. I remember now, the American Military Cemetery, I would say for that design, yeah, it's possibly a bit worse. Possibly worse than the effect on Clare Hall. It's a difficult thing because, they, as I say, they are rather different in terms of their effect. On the one hand, at American Military Cemetery, you've got quite an active highway, whereas for Clare Hall it is a quiet lane. On the other hand, for American Military Cemetery, you're dealing with an area which is actually quite key to people's experience of the asset, both as in terms of its phenomenological experience, if you'll forgive me, and also its materiality. So yeah, it scored a little higher, but not by much.
So and just to compare it, so I realise you use slightly different terminology there. So in terms of the effect of the CPPF scheme, you said towards the lower end of less than substantial, and for this one you said that there was a slight adverse effect. I mean, in terms of your broad categorisation, you've explained that you think the effect would be greater on Mattingly Road, but could they both be categorised as they're both less than substantial? You've already explained less than substantial.
They're both less than substantial.
And towards the lower end was the phrase you used for.
Yeah, they're both towards the lower end. For Clare Hall, it's really further down towards the very bottom. But we're descending into semantics about two rather different effects, I feel.
Thank you. In terms of the, you've noted some adverse effects on a number of designated and non-designated heritage assets in the area. And there's Elmside, which is the listed building, which is sort of a Long Grange Road next to the Erskine building. And there's 5A and 5B Herschel Road, which are a locally listed building, so I've taken that to be a sort of non-designated heritage asset. And I think in both those cases you've identified it's a low level of lesser substantial harm and a minor adverse effect, but not significant. And I think in both cases you referred to it was actually the change in the character of what is currently Rifle Range Road to a busway in terms of the operational effects of moving vehicles. Can I just clarify, have I understood that correctly, or were there other effects of the scheme which would create that minor adverse effect or that minor harm?
Well, where Rifle Range Road intersects with Grange Road, there will be a junction. That is a much more substantial alteration to the setting of assets which include that junction within its setting. And I felt that for Clare Hall, that junction was was far enough down Rifle Range Road that it wouldn't really affect my consideration of how the setting was altered quite so much. But for Elmside, for example, it's right there.
Thank you. And in terms of the non-designated heritage asset, the 5A and B Herschel Road, I think it is. That's obviously closer to Herschel Road than it is to Rifle Range Road. Was the effect? Was that purely about bus movements?
I believe so. I'd have to.
Okay.
I'd have to take that one away and check. Yeah. Apologies.
In terms of the West Cambridge conservation area, and again, just going back to that junction, you mentioned that there's an effect on the setting, but obviously the junction itself is within the West Cambridge conservation area, isn't it? And so is there? Are you saying that, just to clarify again, are you saying there's an effect on the conservation, on the character and appearance of the conservation area itself by that junction and the road, as well as elsewhere where it's not within, where the route of the busway isn't within the conservation area, that it's affecting its setting?
Are you referring specifically to the conservation area?
Yes,
The
yes.
effect
The
on
West,
the
to the West
conservation area?
Cambridge conservation area. Yes.
Okay. So yeah, there are alterations to its character and appearance within the conservation area. I wouldn't place a huge amount of weight on the approach. Yes, there are some. There's a certain amount of additional harm through that, but within its setting. But the main issues are alteration to the character and appearance of the conservation area itself, and also the physical alteration of it for the construction of that new junction, changes to the carriageway, installation of signage, physical changes of those natures.
And the oak tree on the corner, I think it's an oak tree. Is your understanding that's going to be removed as part of the new junction works?
I'm not clear on whether it's being taken off or not, actually.
Okay.
I think there was some question about how the trees along there would be treated. Obviously, well, not obviously, I won't say obviously, but if that tree is removed, that would be harmful.
And again, I just casting my mind back, I think it's one of those areas where there might have been just the detail on plans is a bit difficult to understand, so that's perhaps something we can also clarify. In terms of the further along the route, there's going to be the new bridge at Binbrook with the embankments on either side. Has that been in the heritage statement? I couldn't actually find a reference to that being assessed in the heritage statement.
No.
And was it assessed in your proof?
No, I haven't discussed it because I have visited it, and I don't regard it as being something which will be impactful on the setting of any designated assets. So in that sense, for example, with when you take the setting guidance provided by Historic England, it's a consideration effectively that would have been looked at step one, and it hasn't cropped up. It hasn't caused any other assets to be assessed, and I don't think it. I think rightly it's not included in my assessment of effects on Clare Hall, for example.
I was more thinking about the setting of the conservation area.
Right.
Yeah, given that I think it's immediately adjacent to the part of the boundary of the conservation area.
Right. Well, I think it's no, I don't think that there's an effect there.
Okay,
Because
thank you.
it's the nature of the it's quite a busy boundary. There's a lot of not just vegetation, but thickness of vegetation, not just one tree, but several, and there's a lot of buildings and other either filtering or blocking items in between where that would be and the conservation area.
And just when you're talking about sort of the filtering or blocking effects, are you talking about views from within the conservation area out, or are you talking about views from the south towards the conservation area?
Well, both.
Thank you.
Thank you, Mr. Wilson. Mr. Cameron, do you want to? Oh,
Yes, please, sir.
just check that there are no questions from anybody else on the evidence, the scope of Mr. Wilson's evidence this morning. No. Okay, Mr. Cameron.
Thank you, sir. Mr. Wilson, can we just go back to the questions that Mr. Underwood asked you about the concrete drainage channel? You'll remember those questions. And can we just take up your appendices, please? So this is CD 2601 APP W2-2. Mr. Wilson's appendices. Does the number help or not? Often doesn't. Thank you. Page 41, please. Now, on page 41, we should have a map which shows the listed building at Clare Hall. 41 of your appendices?
It's 43 PDF.
Oh, is it?
Yeah.
Sorry. Oh, mine's... it's 43 paper as well, but in some reason in mine it's 41. But
Right.
so you were asked about the part of the canal which lies to the west of Family Walk. Do you remember that?
Yes.
So when we go west and we get to the Brown Pippard building, is that included within the listing or not?
Brian Pippard building is not included in the listing, no.
And what does the blue area show us? Is that...
The blue area shows building blocks that are included within the listed building. It's not a particularly informative plan, I have to say.
Yeah. Still, it's the one we've got in the list entry.
It is the one formally produced by Historic England.
Thank you. Now, you were asked about the effects of the works to create the busway on the significance of Clare Hall as a listed building, and you were asked about controls over those works because you'd made certain assumptions as to the extent of those works and so on. Can we just take up the suggested list of conditions? So we need to go now to core document 2912, and that should be, if I've got the right reference, the statement of common ground with the City Council, which within whose area Clare Hall lies. And once you've got that, I'd like to go to condition 17, which my PDF is page 24. So CD 2912, page 24.
Right, I have that in front of me, thank you.
And we can see there, condition 17, that a detailed soft and hard landscaping scheme for each phase of the development has to be submitted to and approved in writing by the relevant local planning authority. So does that or does it not give the local planning authority control over hard landscaping and indeed soft landscaping? You're looking at the
which
same
paragraph am I
document as
looking at?
me.
Yes,
I'm looking at
17.
condition 17. No phase, I don't think it'd be necessary to read it out, but I will. No phase of the development, with the exception of the intrusive site investigation works
Right.
approved under condition 4 and the archaeological mitigation work approved under condition 7, which we're not talking about, shall commence until a detailed soft and hard landscaping scheme for that phase has been submitted to and approved in writing by the relevant local planning authority. And the question was, if that condition were to be imposed, would it give the local planning authority control over the details of hard and soft landscaping?
Yes, it would.
And then if we go to condition 19, and to give you a chance to read to yourself what it says, because I don't want to read it all out. But if this condition were to be imposed, would prior written approval of location, layout, scale and external appearance of the busway have to be obtained from the local planning authority?
Yes, yes, it would.
And I think we have, for access, we've got condition 20, but I don't need to ask you about that. So if conditions 17 and 19 were to be imposed, would that give control over the precise details of the layout of the busway in relation to Clare Hall?
Yes, it would.
Thank you. Now, you were suddenly bowled a fastball by the inspector about the American Military Cemetery, thinking you were talking about Clare Hall. So can we just go back to
Certainly.
what you said in your proof? Because it was a question about, well, in effect, if you say that there would be less than substantial harm at the lower end of the range to Clare Hall, how does that compare with your assessment of the American Military Cemetery? Can we just go to your proof at 6.2.11 on page 65? And there you do your assessment and you say exactly what you've said today. A degree of less than substantial harm would be towards the low end of the range, 6.2.11. But can we just have a look at 6.2.12?
Ah, yes.
You say there, this assessment assumes a best case that any land take is only on the southern side of Madingley Road and that no land outside the highway boundary, which includes the verge, would be required. However, if land taken on the northern side of Madingley Road was required, the assessment would need to be reviewed, particularly in the case of the American Military Cemetery and Memorial, as land within their curtilage may be physically affected. Now, what are the likely consequences of such a review on the assumption that the road works were extended to the north? Is that likely to make the degree of impact higher or lower?
Well, the degree of impact would be higher if land was required to the north, and if land within the curtilage was physically affected, then that would be that may be quite a big increase in the level of harm.
And just remind us, we know for the American Military Cemetery it's designated not only as a listed building with the memorial, which opens up onto the road, but it's also a registered park and garden. And when you're dealing with Clare Hall, is there a registered park or garden?
There is not, no.
Thank you. next question, you were asked about the non-designated heritage assets on Herschel Road, 5A and 5B Herschel Road. And can we just go to your proof at 6312 on page 68, please?
Yes.
And do you there assess the degree of impact on those non-designated heritage assets?
Yes. They are found to be less than substantial harm.
Well, and you then refer to the technical report, which we've got as core document. I don't think we need to take it up, but I'm just going to give the reference. CD 11107-2, and as you say in your proof, that assessment is to be found at page 35, paragraphs 6230 and 6231. So that's where we find it.
Yeah, that's where you'll find the detail.
So hopefully that deals with that question. Now the oak tree question next. Can we take up, please, core document 14.5, which is one that you, I suspect, haven't looked at before because it's part of the road safety audit, which is probably not what the heritage expert usually looks at, but let's get it because it's got a good drawing in it. CD 14.5, page 5.
Right, I have that. Thank you.
Now, if you can see that, the oak tree on the corner, is that the oak tree that you understood the inspector was asking about, or some other oak tree?
Yes, that's the oak tree.
Yeah.
That is what I understand to be the one that the inspector was referring to, yes.
And it's shown in green, so is it proposed to be retained or removed?
Green indicates individual trees, locations indicative to be finalised through detailed design stages.
So if it's not removed, will there be any effect on the conservation area?
No.
And if it is removed, it appears to be shown to be retained, but if it were to be removed, that is the degree of impact that you were contemplating in answer to the inspector's question, is it?
Yes, that's correct.
But are you giving evidence on whether it's likely to be removed or not?
My understanding was that it was not to be removed.
Good. Thank you very much. Those are all the questions I've got for you.
Thank you, Mr. Wilson. We'll take the lunch adjournment now and then return for evidence on flood risk from Mr. Southern. Inquiries adjourned. Please return at 1:45. Thank you.